Is there a judgment? Hang on. I haven't started just yet. Wait. No, there is no judgment.
What, your phone?
That's good though. It's all diverted to my own phone anyway. Yeah. Mine's not worth it.
Oh, yeah. Unless you get them to send you a new one.
I think it's nice now.
Yes, Mr. Dunning. I can tell you that we have read the pleadings, the judge's judgment, skeleton arguments, Duke of Bedford's case, Google, and Emerald.
Thank you very much. Well, my lord, we're here in person this time.
Yes, indeed.
The same team, myself and Mr. Cribb and Mr. Jen, and Lord Goldsmith and Dr. Blake for the respondents. And this is an appeal, as you know, against the order which is in Core Bundle tab 8 at page 124, paragraphs 1 and 2 of that order. And that was the order whereby at page 124 there was a declaration that the Bonga community, i.e. those individuals and communities listed in Schedules 1 and 2 to the particulars of claim. And you will have seen those, but probably just flick through those. But Schedule 1 is at tab 13 of the Core Bundle,
yeah.
And Schedule 2 is at tab 14 of the Core Bundle. And the particulars of claim are at tab 12 and 13, the amended, 15, the amended. And it goes on, and the two named claimants do not have the same interest in the claim for the purposes of establishing representative action under CPR 19.61. Paragraph 2, the representative elements of the proceedings, i.e. the claims brought on behalf of the individuals and communities listed in Schedules 1 and 2 to the particulars of the claim, are struck out pursuant to CPR 3.4, leaving only the personal claims of Mr. Jalla and Mr. Chuja in existence. So it's those two paragraphs against which we are appealing, and the essential conclusion that the judge reached in his judgment, which you will have seen, was in paragraph 77 in Core Bundle tab 9 at page 155.
Yes.
Where after a process of reasoning, which we shall be looking at, he concluded that the represented claimants do not satisfy the requirement of the same interest, either as between themselves or as between themselves and the lead claimants. And therefore the proceedings could not continue as a representative action. And it was on that basis, and only on that basis, that he made the order striking out the proceedings, save in respect of the individual claims of the two named claimants. And there's been no respondent's notice seeking to uphold the judgment on any different ground. So we are focused, therefore, solely on that one issue as to whether that conclusion is correct.
In other words, this is not a question of the judge exercising discretion.
Exactly. He did not go on and say, in any event, I would have exercised my discretion. The only thing he went on to say was what he said in paragraph 78, which we'll look at. He said that he would not have struck them out for failure to ascertain the class. which was another point that was
As I
raised.
understand it, that was a point that arose before him. He wouldn't have struck it out on that basis, and no issue arises about that for this appeal.
Precisely. The only issue rises on 77, namely the same, what we would just colloquially call the same interest point. And there's been no respondent's notice seeking to uphold the decision as a matter of discretion. Now, that was a point that was pursued below, and I can, if necessary, I can give you the references to where that was pursued in the skeleton argument. Just for I won't take you to it, but it was it's in the supplementary bundle, tab 20, page 251, paragraph 93, where there were, I think, 4 arguments advanced as a matter of discretion, but none of those have been resurrected for the purpose of this appeal by way of a respondent's notice. So that's a very long way of saying that we are only concerned with one point, namely whether his conclusion in paragraph 77, which was the sole basis on which he struck out the representative proceedings, was a correct conclusion or not. And our submission in relation to that is that the learned judge reached the wrong conclusion in paragraph 77, and he should have concluded on a correct application of the law to the facts and the circumstances of this case that the same interest requirement was satisfied. Now, what I was proposing to do, if it's convenient to your lordship, is to divide my submissions into 3 parts. First of all, the legal propositions and the authorities. And I note that you've read closely some of the authorities already. Secondly, I shall summarise the relevant facts and circumstances, some of which are not fully reflected in the findings in the judgment, but were matters which were before the learned judge. And thirdly, then I shall turn to the judge's reasoning in the critical paragraphs at paragraphs 69 to 77, and explain why, in the light of the legal propositions and the facts and circumstances, we say that he erected too high a hurdle, which would preclude tort cases such as this one, which can conveniently and should usefully and appropriately be brought as representative actions.
At some point in your submissions, are you going to explain, on the assumption that you're right on the scope of the rule, how you envisage this action proceeding? What are the practicalities of a trial judge deciding whatever it is that he or she needs to decide, both as to limitation, causation, extent of remedy, and so forth?
Yeah, I wasn't going to deal with that in detail because we haven't yet. We've got a case management conference in about 2 weeks' time when this is going to be one of the topics, and indeed another case management.
I think I would like to know how you see it going forward.
Yeah, but my essential point in relation to that is because we have disavowed the individual characteristics of the claimants in relation to, so they're not pursuing any individual consequential loss claims. Just taking a very high-level view, the essential point is that however it is done, and Lord Goldsmith will no doubt have other contentions at that case management conference, it won't make any difference that the land and the property is owned by 27,000 individuals and or 450 communities, because no reliance is placed on the individual characteristics of those who own or possess the land or the property. So it would, in other words, it would be the same, whatever the case management is ultimately, would be the same if all of the property was owned by one person. And indeed,
yes, but how does the existence of a nuisance in Ypres show that there's one in Antwerp?
It doesn't, and I'm not. That's never been our case. So we say the judge, I think in paragraph 68, says the outcome might be a patchwork of success, and we say yes, indeed, it might be, but that is no different from what would be the position if all the land was owned by a single owner. And that's not entirely hypothetical, because you may have seen here there was a passing reference to something called the Akenrunten proceedings. Now those proceedings were all brought in the name of the king and his 2 sons, the princes, for a very large area of land, because it so happened in that part of Nigeria, their case was that the king was the person who owned and possessed all the land. Exactly the same inquiry, the point is that exactly the same sort of inquiry about did the oil affect the land and property and when did it come, would have arisen in that case, even though they were suing as the person's entitled to the entire area. You imagine, let's just take it to the UK. Imagine a huge estate in Scotland with 150,000 acres or 100,000 acres. And there is a pollution event at a North Sea terminal, for example, eventually somehow impacts on that estate. And it could impact on different parts of the estate and different items of property within the estate at different points in time. But that would simply be...
And to different levels of pollution.
And to different levels of pollution.
Requiring different levels of remediation.
Yes, but potentially...
So all of that is critical.
But that is not my key point, I suppose, is that that is not a function of it being a representative action, because it would be the same if the property was all owned by one person. That's our answer to that point.
Can I ask I'm sorry, we're taking you out of turn.
No.
Is there any one individual who would be able to lay a claim to full 100% remediation, as opposed to a hypothetical individual who could say so? Is there any one claimant who could stand back and say, well, I have a right to remediation covering the sea, the land, everything, the shrines?
I can't answer that question. Can I just update you on where we are procedurally? So we were under a direction to serve a package of pleadings on damage and evidence, expert and factual evidence, all part of a package last Friday. And a package of material was served last Friday, but it was not as complete as the claimants would have wished because of difficulties in Nigeria. And so they have asked for an extension of time to supplement the package with more material. And that is something that we will hope will be addressed at the case management conference in less than 2 weeks' time. Not next
Does that
week.
include the date of damage pleading?
Yes, that is the date of damage pleading.
Right. I would be, obviously having done the judgment on the limitation material, I would be interested to see that.
Yeah.
And I think that, speaking for myself, it may not be irrelevant to the issues that we have to consider in this appeal.
Understood.
And can I ask, so, I mean, obviously not now, but that would be a good thing to see. Can I ask, is that material served effectively in relation to the two appellants? Because they are, at the moment, they are the only two claimants.
No, it is served in relation to them, but it is served in relation to others as well. But it's not complete in relation to others, and hence there's an application for extension of time in relation to the others. But there is an expert's report,
right? So
and there are some witness statements.
So
as well.
it's a date of damage pleading that is advanced beyond the two appellants, but not the 28,000 individuals and communities.
It is for some. It is for some,
well,
but it isn't complete.
Not for,
it isn't complete,
for,
and that's why we're seeking to have an extension of time to complete it. But it does cover, I think, a number of other communities, and also, I'm told it's only one of the two appellants at the moment, but I don't know why that is. I was not in, that was a process that was completed on Friday, and I was not closely involved with that, or not really involved with it at all. But I can,
You say that it does cover some of the people who, at the moment, stand struck out.
I'm told 5 other individuals and 5 communities, and an application has been issued for an extension of time to be able to serve in relation to others as well.
What, the 28,000?
Well, as many as we can get the material in relation to, as I understand it, in the time.
Because the order was for all of them.
Yes, yes, because, and the reason is for that is because the representative proceedings are now the subject of common directions with another action, which was started much later in terms of time, but which is in the names of all of the individuals.
This is the one you call Jalla 2, is it?
Yes, or the protective action.
Yeah.
Yeah. But so in a sense, what we're fighting about here is the gap between Jalla 2 and Jalla 1 in terms of limitation.
Yes, quite.
Well, as I say, speaking for myself,
Yeah.
although there are quite a lot of files, I would be interested to see the material that was served in accordance with the judge's order in relation to limitation.
Yes. Now, so turning then to the legal propositions, and in view of your reading, would it be convenient if I gave you the propositions and the references, and then we go to the cases?
Yes, by all means.
So our first proposition is that the leading case on the relevant approach to the requirement of same interest under 19.61 is that formulated by the House of Lords in the Duke of Bedford case, which is at tab 2 in the Bundle of Authorities. And in particular, the correct approach remains that articulated by Lord Macnaghten in Duke of Bedford at page 8, which is in the Authorities Bundle at page 49, and where he said, and I'm sure you noted this when you read it, that the claimants must have a common interest and a common grievance, and the relief sought must in its nature be beneficial to all. And he also said, however, on the previous page, page 7 in the report, that the court should focus on what is common to the claimants, not what differentiates them. Now, so that's the test and if necessary, we can go back and have another look at that. And that test has been followed and applied many times. For example, it was discussed and followed and applied by Mr. Justice McGarry in a case called John and Rees, which is at tab 5 in the Authorities Bundle, at page 569G, and it's in the Authorities Bundle, page 126. I'm sorry, that should be 369G to 370E, and also 370D through to 374C. So that's in the bundle numbering at pages 126 and 130. And that was a case where you I don't think you've indicated that you've read that one yet, but there was
It was a Labour Party.
It was a dispute about the Labour Party, exactly. Yeah. And so there was one of the in the intervening time, one of the lengthy discussions. That was not a short case. I think it lasted like 15 days, and there was a lot of argument and a very detailed judgment on that point. More recently, that the test from the Duke of Bedford was applied by the Vice-Chancellor in the Independiente case, which is at tab 12, and you'll see that at paragraphs 22 and 23, and then he applies it at paragraphs 24 and 30. And that was one of two cases which are of particular interest because they were breach of copyright cases, in other words, tort cases, where the representative action was brought on behalf of all members of the British phonographic industry. And in those two cases, the other one being the EMI case, although all the breaches of copyright would have been separate breaches of copyright, and claims would belong to each of the copyright holders, a representative action was deemed appropriate. So we'll look at those a little bit. So the test was applied by the Vice-Chancellor in the Independiente case at tab 12, and then the test was applied most recently by the Master of the Rolls in the Google case at tab 20, at paragraph 75 in his judgment. And of course, I'm sure you appreciate that the Google case has now been argued in the Supreme Court.
Yeah, at the end of April, I think.
At the end of April, one can, these being the times they are, one can watch the arguments on the video.
I have not.
one of my juniors has. I mean, the representative action point is not the only point in that case, because there's clearly there's a prior point about what is the nature of damage under the Data Protection Act, Section 13, anyway. And there was a lot of debate about that. So those are the cases which we say establish the right approach, and most recently have followed it. Second proposition is whether the same interest test is satisfied should be decided based on the allegations in the claimant's pleading, without seeking to resolve disputed issues that may arise from that. Now, that is actually a very important point here, because the learned judge below did not do that, in my respectful submission. Now, the authority for that proposition is the Duke of Bedford case, again, Lord Macnaghten at pages 7 and 11, and most clearly, however, in Lord Shand's speech at page 15 in the Duke of Bedford case. And then one sees that as one of the propositions of law which was summarised by Mr. Justice Aikenhead in the Mill Harbour case, which is another quite important recent case, which is in the authorities bundle at tab 15, page 449, where in paragraph 22 in the Mill Harbour case, Mr. Justice Aikenhead summarised the law, I think in 7 propositions, which is a very useful summary. And this was his proposition 4, so it's paragraph 22 brackets 4. So one shouldn't seek to resolve disputed issues that may arise from that. Obviously, one can look at the pleading and see what is likely to make an assessment as to what is likely to happen. But one should assume that the class will, if they assert that they have, they are growers, for example, in the Duke of Bedford case, they were asserted to be growers, and they were all asserted to be growers. And the House of Lords says, well, we're not going to decide now whether they're growers or not. They rejected, that they refused to entertain the arguments that certain persons didn't qualify as growers.
So you assume that when they say they're growers, that's assumed?
Exactly. And that's what Lord Macnaghten is saying at pages 7 and 11, but most clearly in Lord Shand at page 15. And then summarised by Mr. Justice Aikenhead in his paragraph 22, proposition 4. So this comes back to the learned judge below's point that some of them may fall by the wayside. Well, yes, they may fall by the wayside. This is his paragraph 68. But the fact that
the representative action is essentially a means of managing a case.
Yes.
So I would have thought that in looking at whether there is a useful purpose to be gained
Yes.
in a representative action, one does need to look not simply at the claimant's pleading, but form a view about what issues are likely to arise, and then to ask oneself, well, is this a useful way of trying
Yes.
the issues which one can see have arisen, having looked at both sides of things?
Well, yes, but we're actually on a different point, which is not the discretion of whether it's overall useful, but whether it satisfies the same interest test. And for the purpose of the same interest test, one has to proceed on the basis that the allegations will turn out to be true. Now, it may well be that they don't for all of these people. I mean, let's assume, let's say 50% of them are unable to prove that their property was damaged by Bonga oil. And that's what the judge was talking about, where he said some may fall by the wayside, there might be a patchwork of success. But that is not a reason why it is not appropriate for representative action, in my respectful submission. And And I think also another point I would make in response to your question is just standing back for the moment. There are only two ways that this sort of proceeding can be done, obviously. There's a representative action and there's a group litigation with a group litigation order. And if it can't be done in one of those two ways, then there's an access to justice problem under Article.
Well, that's a fundamental point.
Yeah.
And since you've raised it, let's just deal with that. I don't understand that submission, that there are only two ways of dealing with this, a representative action or a group litigation order.
Well,
I mean, somebody has been to the time and effort, and I imagine it took absolutely ages, to identify over 27,000 individuals and almost 500 communities affected by the Bonga oil spill. They're named in Schedules 1 and 2. Conventionally, that's a way you do it if there are going to be, effectively, 27,000 claimants.
yes.
And then for trial, you identify, you take a geographical spread, you take a spread of claimants that have suffered particular damage as a result of particular effects of the oil, some greater than others, and then you work out, because the claim is in relation to remediation, what an appropriate remedial scheme is, and then you extrapolate.
Yeah.
You don't have a representative action, you don't have group litigation order. You do what the TCC does for years, you do sampling.
Well,
why can't that happen here?
Well, I am not going to argue that it can't happen, because my submission, if I need to make it, is that representative actions and group litigation, or that approach that you've just outlined, are not mutually exclusive.
No, that may be right,
yeah.
but at some point, speaking for myself, I will need to understand what the magic is here of a representative action as opposed to the sort of sampling process and extrapolation from that with which so many of these cases are done.
Yeah. Well, I will. Maybe that will be covered by some of the other points I'm about to make, but if not, I will try to come back to it, my lord. The third proposition is that the requirement of the same interest is, according to the many authorities, a flexible tool of convenience in the administration of justice, and it is not to be applied narrowly or restrictively, and it's to be used as a mechanism which is convenient for the pursuit of the claims for the benefit of both sides and for the courts. And in the words of Lord Justice Jackson, in one case, it's not to be used as an obstacle course. So there are a number of points that are associated with this. One is, and it's a point that was made in the House of Lords in the Taff Vale case, I'll take you to it very briefly, that it's not necessary to point to a previous case where exactly the same use has been made of a representative action. It's sufficiently flexible to be applied to new situations as and when they present themselves. And there are also a number of cases which have said that since the advent of the CPR, the rule must be construed in the light of and in order to facilitate the overriding objective.
National Bank of Greece, I think.
Exactly, that's Mr. Justice Andrew Smith, which we referred to in our skeleton. So just briefly on this, the cases were Lord McNaughton again at pages 8 and 10, who called it a simple rule resting on convenience, and Lord Shand at page 14. The Taff Vale Railway case, which is the next tab in the authorities bundle, tab 3, at pages 442 to 443, where Lord Lindley made the point that one doesn't need to point to a previous case where there's been which is the same on the facts. John and Rees again, by Justice McGarry at tab 5, and particularly in the law report at page 370 E to F. The case where Lord Justice Jackson said it wasn't to be used as an obstacle course is a case called Williams and Devon County Council, which is in tab 17. and he said that at paragraph 31. And then finally, there was, in the Independiente case, which I've already referred to, Vice-Chancellor Sir Andrew Morritt spoke of the need to apply the rule flexibly and in accordance with the overriding objective, and that was at paragraph 23 in the Independiente case. And that has resulted in the White Book saying, and this is quoted in our skeleton argument in paragraph 62, and I'll just read it. It is suggested, they say, that Rule 19.6 is designed to allow representative proceedings to be treated not as a rigid matter of principle, but as a flexible tool of convenience in the administration of justice, and should be applied not in any strict or rigorous sense, but according to its wide and permissive scope. The dictum of Mr. Justice McGarry to this effect in John and Rees, and then has been repeated with approval in many subsequent cases. So that's the third proposition. The fourth, it is easier in our respectful submission to find that there is the same interest where the represented parties have given their authority for the claims. So this sort of starts to intersect with the point that Lord Justice Coulson put to me a moment ago, which is this is somewhat unusual, this case, because the individuals and the communities that are represented here have in fact given their authority for the claims. So this is not like the Google case, where Mr. Lloyd starts proceedings without any contact with all the people he purports to represent, the 4 million people who had their personal data taken by Google. This is a very different case where and that was a point, I think, that particularly concerned Justice Burroughs in the Supreme Court, for example, that individuals might be bound without having given their authority for the proceedings brought by Mr. Lloyd. And particularly, for example, you can see that if someone's a heavy data user, but their claim has been restricted by Mr. Lloyd in bringing the representative proceedings to £700, they might feel aggrieved by that. Now, that was one of the points in the Google case, but it doesn't arise here. Nor did it, and it was also a point that weighed heavily in the Emerald case, which you've read as well, that in the Emerald case, the proceedings were brought without authority on behalf of a hugely wide class of direct and indirect users of British Airways freight services across the entire world. Now, our case is different because the individuals have given their authority for the claims, and the added element as well, you'll see when we come to the facts, which is something the judge didn't reflect in his judgment, although we did discuss it during the course of the hearing, is that the claimants have actually agreed inter se how the damages should be handled. So there is a management committee, sometimes called a steering committee.
Are we concerned with that? I thought the whole thrust of the case now is remediation, not damages, and damages is Jalla too.
Not individual damages, but we are concerned with remediation, either an order to remediate or damages in lieu to pay for the remediation.
So you're splitting the damages into compensation for damage already caused and cost of remediation.
Yes, so this action is concerned with remediation, and either an order that they clean up, or if that can't be made, and Lord Goldsmith says it can't be made for various reasons, an order that they pay for the cleanup, and that would then be an order for a sum of money which will be handled by the committee in this particular case.
This paragraph 67 of your pleading doesn't quite, it doesn't go on. This is in light of the defendant's woefully inadequate attempts at clean-up and remediation. They didn't claim damages and the value of the cost of design and implementation of clean-up.
Yes, and it's in the prayer. Really, what we've done, just to summarise, and I don't want to go over again what we debated in December, But what we've done is we've dropped paragraph 1 of the prayer and are pursuing paragraphs 2, 3, and 4 of the prayer.
It's paragraph 3 of the prayer. Yes.
So those are
Do you
two.
have a? Because we did go over this in December. I wondered whether there was any development as to which the preference was. We had some debate about that, I seem to remember, in December. Is there a primary case? I mean, you put it just then, as you put it in December, namely, we'd like an injunction in the alternative or failing that, damages. Is that the...
No, that hasn't progressed because the date that is not covered by the date of damage pleading, as I understand it.
No, it wouldn't be. I wondered whether there was a preference as to which the claimants wanted.
Not at the moment.
Thank you.
Now, the next, so on this proposition, which is to do with authority and agreeing how the damages should be handled inter se, we rely in particular on the two British phonographic industry cases. So that's EMI, which is at tab 8, which is a decision of Mr. Justice Dillon, and we rely on page in the report 925 C to D and 926 D to E, and again the Independiente case, which is at tab 12, Sir Andrew Morritt, Vice Chancellor, at paragraphs 27 and 28, and also Emerald Supplies, which is tab 14 in the bundle, at paragraph 4 by
Paragraph
4 per Lord Justice Mummery. And as I shall be showing you when I come to the factual parts, in the present case, there is a constitution behind the claimant class and a management committee or steering committee to handle the damages with the authority of all of the claimants and the communities. And the fifth proposition is that the requirement of the same interest does not mean that the claimants must have suffered the exact same loss. None of the case law requires that the claimants must have suffered the same loss, or that their position on the facts must be the same, and it doesn't require their position to be the same either between themselves or between them and the representative claimants. And one can test that immediately by reference to the two British phonographic industry cases, EMI, which is tab 8, and Independiente, tab 18. In those cases, quite evidently, the holders of the copyright were not in the same position. They each held copyright in different bits of music, and their copyright had been infringed in different ways. And they each had to prove damage in order to pursue their claims. But it was nevertheless held in each of those two cases that it was appropriate to proceed by means of a representative action. There is also another case on this proposition, which is Prudential and Newman. Now, Prudential and Newman, of course, was a famous case about reflective loss, which has recently, and that aspect of the case, and the Court of Appeal's decision on reflective loss has recently been, as it were, vindicated by the Supreme Court in the Marix case last year. But I'm not talking about that aspect of it. At first instance, Mr. Justice Feinlot, in a case which was brought in the tort of conspiracy, held that the various shareholders could be who were seeking damages for tort conspiracy could be represented by a representative claimant. So clearly, they all had different. They each had different loss, and that judgment is at tab 6, page 303 C to D in the law report. And finally, this proposition about not being in the same position is illustrated by Lloyd and Google at paragraph 75, which is the Sir Geoffrey Voss's key reasoning in that case. And I won't read that all out now, but when he says that the 4 million people who've had their personal data extracted by Google without their consent, he said they could all they all had the same interest. Now, clearly, in each case, it had to be shown that they hadn't consented to their data being abstracted. So that was the one thing that Mr. Lloyd could not concede. But subject to that, Mr. Lloyd said he would restrict their claims to, I think, £700 each, even though some of them may have suffered no loss, really, as a result of the extraction of their personal data, and some of them may have been had a lot of very sensitive personal data and may have suffered a quite different loss. Now, the Master of Rolls, Geoffrey Voss, called that the same damage, but what he must have meant in paragraph 75 when he said that was he must have meant the same type of damage, because they clearly hadn't suffered the same loss, because they each had a separate, each of the 4 million or however many there were, had each had a separate loss of their own separate personal data. So the sixth proposition is that there is no bar to a claim where the represented claimants have to prove their own damage as part of their cause of action, even if that involves consideration of some element of the individual position of represented parties. And it follows from that, and it's established, that CPR 19.61 is available for tort claims, even though damage is an element of the cause of action. Now, we rely on the same cases, Prudential, EMI and Independiente for that proposition. Also, the summary by Mr. Justice Aikenhead in Mill Harbour, which is at tab 15, in his paragraph 20, where he says, and I quote, "As the law and practice has developed, it has been held that a claimant is entitled to sue in a representative capacity for others and seek damages." And of course, we rely on the Google case, for the reasons I've just explained, and in a contractual context, but nevertheless discussed in some detail, was the Irish shipping case, which is at tab 10, where Lord Justice Staunton considered the argument by Mr. Pollock that they all had to actually suffer the same loss, and they had to be at exactly the same position. And he rejected that argument at 227B in the Irish shipping case, albeit it was a contractual case. So we say, this is then the seventh proposition, that some degree of individualization is permissible within the structure of a representative action. And just to give you an example of that, the Duke of Bedford case, you may have noted when you read it, that although they were seeking a declaration of right on behalf of all the growers, part of the relief in that case was the taking of an account on behalf of each individual grower as to how much the Duke of Bedford owed the individual grower for having charged the wrong sums, I think, over a period of 5 years. So that was not the fact that they were seeking an account, which would necessarily involve looking at the individual position of each grower, was not a bar to the representative action. That's Lord Macnaghten. One could see the account is referred to in various places, but it's referred to by Lord Macnaghten on page 7 in the report. And equally, in Prudential, at tab 6, page 303, C to D, Mr. Justice Feinlott said there would have to be an order or inquiry to ascertain what loss the different shareholders had suffered. And in EMI, which is the one of the two photographic industry cases, tab 8, Mr. Justice Dillon directed an inquiry as to damages at pages 926G to 927A. Then the next proposition, it is no bar to being representatives that the named representatives also have their own individual claims in addition to the claims that they're bringing on a representative basis. And one can see that in the Duke of Bedford's case.
Well, that must be right.
Yeah.
Otherwise, there's no point in bringing an action at all.
But even if their individual claims are over and beyond their... So in this particular instance here, for example, the individual claims that Mr. Jalla and Mr. Chuja are pursuing are for consequential losses, as well as for the property damage per se. That's the point. And in that case, Lord Macnaghten, you see that from Lord Macnaghten's speech on page 7, the last 14 lines on page 7, and Lord Shan's speech on page 17 in the first full paragraph, where he makes that very clear.
And here, the individual claims are in Jalla 2.
Well, the individual claims of the representative, of the represented class are, but in Jalla 1, Mr. Jalla and Mr. Chuja are still pursuing their I call them consequential loss claims because it's better to
never ever use the expression consequential loss because people end up arguing hugely.
But
anyway,
I'm trying
it's not
to
consequential loss. It's their claim for damages. But so leave aside the two appellants. The other 28,000 people, there's their claim for if there's not an injunction, their claim for the damages for the cost of the cleanup. That's Jalla 1. Yeah. But the loss of the harvest in a particular year, or
loss of profits from
that's all in Jalla 2.
Yeah.
And Jalla 2 is...
It's a protective action.
Yeah.
I mean, it's one to try to stop time running anymore as while this appeal is pending. Effectively.
Yes.
Yeah.
So again, you'll deal with it, but the proposition that I put to you earlier, you wouldn't have any of that complication because you'd have claimants and they'd simply be making their claims.
Yeah. And yes, I mean, I see that. But the question is, what was the learned judge right to say that this action should be struck out with the extra time bar problem that entails, because there isn't the same interest, and that's the only issue we're here for. If he was wrong to say that,
but the test is the same for all practical purposes, and we mustn't lose sight of the all practical purposes, which is why I do need. For myself, I do need an answer to that point at some point. Why are we here arguing about a representative action when we have 28,000 people who are quite prepared to be claimants?
Because I mean, the answer is
limitation.
Because that's the way it was commenced, and it wasn't commenced in the alternative
it wasn't
until later.
That way, was it? It
was
by the two individual claimants.
But then by amendment,
and they later added in the representative capacity. So
exactly, but not as late as the
no.
In April.
This at bottom, this is really all about limitation, isn't it?
That's the consequence. I mean, it is. But the question is, are we right or is the judge right on the same issue point, the same interest point? And if we're right, then we don't suffer that limitation problem. If we're wrong, we do. So the next proposition, and I'm sorry, these do overlap, but they are separate propositions.
So we're up to number 9.
We are up to number 9, and there aren't too many more. Is the availability of a defence against some but not all of the claimants does not necessarily mean that they don't have the same interest in the claim, and what weight should be given to that factor depends on assessing all the circumstances. And again, one can see that in the Duke of Bedford case, that the claim for an account would require consideration of the individual circumstances of each grower. In EMI and Independiente, the assessment of damages for breach of copyright would require consideration of each copyright holder's rights separately for each piece of music. And this was also discussed in Mill Harbour at paragraphs 26 and 27 and 31 by Mr. Justice Aikenhead, and where he said, and I'll just read this out, we are having a transcript of these proceedings, by the way. We've also got live note, although with the 90 seconds delay, it's not as useful as it otherwise might be. But we will
You'll supply us with the transcript.
We will supply you with transcripts, yes, of course. But he said, in that case, if it emerges there are any particular defences which only apply to individual flats of persons who are not actual named parties, the defendants are perfectly entitled to raise them, and to the extent they are established, the defendants may well benefit. It's of course possible that such defences may not reduce any damages which are recoverable. Alternatively, to the extent that damages are recoverable through the medium of the service charge, appropriate declarations can be made to secure that non-party leaseholders to whom the successful defence applies cannot enforce the judgment. So he took a very pragmatic view that any differences by way of defences can be simply dealt with by suitable directions. The final point, as you may have noted when you read the Emerald case at tab 14, that in paragraph 4 again, Lord Justice Mummery said that separate defences militate against representative action, but he didn't say it was a bar to them. Then there's the question of the 10th proposition relates to limitation. And now there's a simple way of dealing with this, which is that the representative action can be limited to the relevant date for limitation purposes. And that's what Mr. Justice Aikenhead did in Mill Harbour at tab 15. And it's in his judgment, it's paragraph 22, proposition 7, and paragraphs 34 and 35. And we respectfully submit that from a case management perspective, one should always impose the less draconian remedy if there's another way of dealing with it, which is to restrict the representative capacity to those who have an interest before a certain date. That is obviously a less draconian way of doing it than striking out the proceedings because there is an issue about limitation.
And was there a date suggested before the judge?
Well, I think the date would be, the dates, let me come back on that. I don't know if we did get into that discussion before the judge, although we did make that point.
You can't criticise the judge for not coming up with a date if one wasn't in argument before him.
Well, we certainly made the point that was the way it could be dealt with.
Well,
maybe he wasn't.
It can be done.
Yeah.
It's a question of whether anybody's saying it should be done in this case.
Yeah.
But it's not an easy date, is it? It's not like there's an explosion in a factory. It's a one-off event and its effects are immediately felt. We've got an oil spill carried by the tides.
Yes.
Making its way up the river delta.
Yeah. Well, then, I see that. But then the other point in relation to limitation is that it is simply a defence. And we come back to the issue that the fact there may be different limitation points is not a function of it being a representative action. It's a function of the geographical spread of the oil. And it would be the same if all the property and all the land was owned by one person. That one person would still have to prove at what point it damaged this bit of his property and then it went a bit further up the river and damaged another bit of the property.
Well, that may be right, but then, I come back in a way to the same point. What is the utility of representative action if all the same issues would have to be gone into as would be gone into if there were 28,000 claimants.
I mean, and it's the same answer that it came for that's how it was done by those before I was involved, and there is a time problem as if this
no, I follow.
proceedings
But,
are struck out.
your proposition. Your proposition, which one it was now, saying that it was a flexible tool for the administration of justice,
Yes.
really does ask one to consider what is the utility of it. And I appreciate limitations, overcoming the limitation problem, but that's not really what a representative action is designed for, is it?
No. Of course, it's not designed for that. I mean, but I didn't say that was the utility of it. In fact, I was going to come to this. My 11th proposition is really a collection of these wider points. And the first of a number of connected points is that, in my respectful submission, representative proceedings are a suitable and convenient way of having claims of a large number of claimants who have suffered from a single pollution event brought before the court. Now, can I just say what the related propositions are? Then perhaps we can discuss them. Secondly, and amongst these propositions, there is no case holding that 19.61 proceedings and group proceedings are mutually exclusive. And I don't think that one could argue that they were, because they've had a different history and they've just simply come in at different times. The 19.6 is a very long history, going right back into the early 19th century at least. I would submit that there will be cases where both might be available, quite properly available. But what the court should do is not erect an obstacle to a representative action if it's then going to be argued that a group action is unwieldy. And in this particular instance, Lord Goldsmith did argue that a group action was unviable. And the reference on the transcript for that is Core Bundle, page 1078, page 68 of the transcript, line 24. So he wasn't prepared to concede that the proceedings could proceed as a group action either.
Well, I think we can proceed, can't we, on the basis that nobody is suggesting a group action is appropriate or a group litigation order.
Well, I wouldn't rule that out, but it's not my argument today. But certainly Lord Goldsmith was arguing against it. So those are the related points that in relation to the bigger picture. The group action, of course, could be very unwieldy. I mean, you might have to have a group register, with each claimant having to take advice on the filing of information in the register. And that, in many ways, that can be less attractive and less practicable than a representative action where there is a management committee sitting behind the lead claimants who have, and all the claimants have given their authority for that structure to be put in place. So,
well, except that in group litigation, it's the common issues which are tried together. So, were the defendants negligent, for instance, in the way they ran their rig? What did a one-off event amount to a nuisance at all? Which is one of the points Lord Goldsmith argued last time round. All that would be dealt with individually, dealt with collectively. But then when it came to damage, each individual who had signed up to the GLO on the register would have to plead their individual case. This is what I suffered as a result of this pollution.
So the way that we see this case proceeding is that the damage to the property will have to be proved. But it won't matter that it's owned by A or B or it's community A or community B, because it's that what we're asking for is that the damage be rectified, either by an order to rectify or damages in lieu. And that doesn't turn on the individual characteristics of the persons who own or control that property that's been damaged. And that's why we say this case is analogous to the reasoning of the Court of Appeal in Google. And can I just finally, the final proposition is that we do have, you probably noticed, some specific points about not having to prove loss in relation to damage to fishing rights, which were in our skeleton argument of paragraphs 47 and 48, and supported by the decision of the Court of Appeal in Nichols and Ely, which is at tab 4 in the authorities bundle. And I noted that Shell has not disputed those points. They may not take us very far, but they haven't placed those matters in issue.
And the fishing rights are what, both in the open sea and up the river?
No, it wouldn't be in the open sea. It would be in the
delta
region. Yeah. Now, I could now go through all of the cases, but you might find it more convenient for me to go to the facts rather than. I mean, what I should tell you. So
you can't necessarily assume that we have already read all these cases.
No.
Well, will be the ones that we've all read. Some of us may well have read more.
Maybe I should do the cases, but do them really quick. Try them as quickly as possible if I can. I mean, so if we could, and what I will try to do is to take them in the order they are in the bundle. So that will hopefully speed things along. We won't be dodging around too much.
I mean, if it's of any help for you to know, you can't expect an extempore judgment, so we will have time to.
Well, quite. That's what I was.
Cases.
That's what I was thinking. But let me take them quickly then. Just so first of all, in tab 2, we have the Duke of Bedford's case, and I won't dwell on the facts too much. But if you go to the second page, just below the headnote, where's the summary of the facts? This is now AB 43, looking at the bundle page numbering. It's page 2 of the report. If you see the second paragraph there, which is by the statement of claim, and you read down about 10 lines, you'll see that they were also claiming an account of the sums charged in excess during the 6 years preceding the issue of the writ. So that would be each individual grower wanting their individual excess to be assessed.
Can I ask you a point about the distinction that was made by Sir Geoffrey Voss in Google between the damage and the nature or type of the damage, and how far that goes? I mean, in the present case, there is damage alleged to across the coast, to fishing rights, to agrarian rights, to impact on shrines, and so on and so forth. And you haven't pleaded that any one individual would have suffered the complete litany of damage, but cumulatively, these thousands of claimants will, as a patchwork, have had their rights, you say, impacted upon by the pollution. What do you say the broad type of damage, if you sort of apply Google, which is uniform across all claimants? I mean, is it enough to simply say remediation, or is remediation really just an oversimplistic?
It's damage by contact with the oil and the oil residues.
Is that
and that's why
to loss of control in Google?
Well,
it's interference with possession of land.
Yeah,
is the damage that you need to show.
I mean, that's why I appreciate it's not been accepted, but why I've tried to distinguish between what I call property damage and consequential loss, and which is not being pursued anymore in this proceedings. Loss of profits, loss of fishing.
But consequential loss could only be loss consequential on interference with possession.
Exactly. So, but we're concentrating now in this proceeding simply on the physical damage aspect. That's the way that I see it.
So I think it boils down in legal principle terms to whether or not it's sufficient to say physical damage to property is a unifying factor in the same way that loss of control was in Google. You then have to break it down further and say harm to the coast, harm to 5 miles up the estuary, harm to the crops, which were 10 miles up
Yes.
the stream,
Yes.
it becomes much more differentiated. So it's a question of what level you use that sort of
Yes.
homogenising term.
And this is what the judge talked about, the evidential difficulties. But in my respectful submission, and we'll come to this when we come to the judgment, the evidential difficulties is another matter. It doesn't mean there isn't the same interest. The interest is the same. I mean, we'll come to the facts in a minute, but before we even get to the coast, we have a huge inquiry about what actually happened out offshore at the loading installation, why the pipe leaked, and why the leak wasn't spotted earlier.
Well, the judge accepted that those were common
He did,
issues.
he did,
So
yeah. We'll come to
doesn't
that.
arise. That's why that's hence
It has
Lord's
time.
question as to damage.
It's as time goes on that the differentiation begins to get greater, doesn't it?
Well, the timing gets different, but the damage we are suing for in this proceeding is the same. It's namely that it's the pollution by crude oil.
Yeah.
And just stepping back, I mean, this case has an odd procedural history, but imagine that this was a case which was commenced as a representative action following a disaster in the North Sea. And for all the people whose property along the coast of the North Sea and up river estuaries suffered. And they had suffered, and in respect of their property being affected by the oil. That's the analogy that we're seeking to draw. We say it would be the same. It's the same cause of action. It's the same facts. It's the same oil. Yes, it's arrived and impacted on different bits of property at different times, but that doesn't mean that they don't have the same interest for the purposes of 19.6.
So if there were a disastrous train crash, you'd say that one of the injured passengers could sue on behalf of all of them as a representative?
Yes.
You would?
Yes, I think we would. Because this is, the representative proceedings are sufficiently flexible to take into account the different position of the different parties, to have an account or inquiry. I mean, this is where I think we part company with the judge, because there's another phrase that he used about it being monolithic. Now, he says in one part of his judgment, he originally thought that the claim was monolithic, and that it was all the impact was along the Atlantic coast and at roughly the same time. But it was never monolithic in a legal sense, because even at that time, when he was thinking of that was the position, each individual piece of property had to be shown to be impacted, and the extent of the impact and the remediation that was necessary. So it was never a monolithic case in the sense that the judge used when he discussed that in his judgment. And he said it might have been different if it had remained what he thought, which is a monolithic case. Well, it never was a monolithic case. And it is always, so when we look at, for example, we will in a moment very quickly, Mr. Justice Aikenhead's decision in relation to the 350 flats, he didn't see a problem in accommodating individual defences to do with individual flats within the structure of a representative action.
So your point is that on the scale of uniformity, you hit the point of similar interest somewhere along the scale, but you don't have to go all the way to the end.
Exactly. You don't have to have this. It is not the law, as one of my propositions, that you all have to be in the same position or to have suffered the same loss. It has to be the same type of loss, probably, in order to have the same interest. But clearly, in the breach of copyright cases, they didn't all suffer the same loss because they each had a separate copyright in a separate piece of music which was infringed.
At some point in time, there was a violation of that copyright.
Yes. So let me try and go through a little bit more quickly, because I do want to then get onto the facts, which it won't take very long, but there are one or two points to draw out. So the key passages I've already mentioned. in Lord Macnaghten's judgment on pages 7, where just before the break in the paragraph, he mentions, for example, that they were seeking an account of the monies by which they alleged they have been severally overcharged. So clearly there they were going to be looking at the individual position of each grower. And then about 10 lines from the bottom of page 7 in the report, he says, if the persons named as plaintiffs are members of a class having a common interest, and if the alleged rights of the class are being denied or ignored, it does not matter in the least that the nominal plaintiffs may have been wronged or inconvenienced in their individual capacity. That was another one of my propositions. And then at the bottom of the page, the last 5 lines, he says, in considering whether a representative action is maintainable, you have to consider what is common to the class, not what differentiates the cases of individual members. And we would respectfully submit that the learned judge has focused more at Paul Goldsmith's invitation on what differentiates them rather than what is common. And then over the page, about 10 lines from the bottom of page 8 in the report is the sentence which begins, it was originally a rule of convenience. For the sake of convenience, it was relaxed. Given a common interest and a common grievance, a representative suit was in order if the relief sought was in its nature beneficial to all whom the plaintiff proposed to represent. And that's the particular paragraph that's been cited many times. And then if you go to page 10, there's a paragraph starting there is one point, and about 7 lines down in there, he says, but in all other respects, I think the rule as to representative suits remains very much as it was 100 years ago. He said this in 1900. From the time it was first established, it's been recognised as a simple rule resting merely upon convenience. And then over the page, this is the point about it being judged off the pleadings, page 11. My lords, it would be highly improper at this stage of the proceedings to say anything which might prejudge the construction of the Act. That's a matter for the hearing. And then in the next paragraph, he says he wasn't going to decide whether they had no rights at all. Then if we go on to Lord Shand, page 14 in the report, in the second paragraph, he says, he talks about the rule and the background to the rule. And then over the page, at page 15, one gets a very clear statement in the first entire paragraph on page 15.
Well, just starting at page 14, Lord Shand in the second paragraph of his speech says the rules being framed and adopted for a useful and important object, the saving of the multiplication of actions with the attendant costs in cases where one action would serve to determine the rights of a number of persons in question with another party called as a defendant. You've made the point several times that the same inquiry would have to take place whether there is one plaintiff or one claimant or 28,000 claimants. So what is the saving of actions and attendant costs if exactly the same process has to be gone through?
Well, it's a simpler action because it's a representative action, just the 2 claimants, and behind them is the committee which will deal with the conduct of the matter rather than having to take instructions from individuals.
So it's a taking instructions point.
Well, let me show you the evidence on that in a moment. But and then over the page, there's the point about deciding it from the pleadings in page 15. He says, 7 lines into the first full paragraph, for the purpose of the present preliminary point of procedure only, these statements must be taken to be true. And on this assumption, the question raises, does the rule of court apply to the action? Right, and now, then moving on, tab 3, I mentioned very briefly Lord Lindley's comment which is in the bundle at page 85 in the bundle numbering. Don't want to spend too long on this, but on page 85, in the first full paragraph, he said the principle upon which the rule is based forbids its restriction to cases for which an exact precedent can be found in the reports. The principle is as applicable to new cases as to old and ought to be applied to the exigencies of modern life as occasion requires. And then...
And you rely on that because there is no case, is this right, in which a representative action has been permitted in cases of nuisance
or large-scale pollution.
Yeah, but I mean more widely, I think. I mean, I don't think any of the cases, I haven't read them all, but I don't think any of the cases are, as it were, nuisance cases.
No, and of course, I mean, although we focused, my lord, on nuisance last time, we do have a case in negligence as well.
Yeah, I understand that. No, I understand that, but I don't think any of these are, as it were, what I would think of as a negligence case in the sense of, you know, in the normal run.
No, I mean, there are relatively few tort cases, but as I say, Prudential and Newman was one. The breach of copyright, I regard breach of copyright as a tort. And so the two tort cases, the two breach of copyright tort cases, the EMI case and the Independiente case. And Google, I suppose that's a statutory tort, is it?
I was going to say that's a statutory claim.
Yeah.
Breach of statutory duty.
Yeah. I call that a statutory tort, but that's just a question of terminology. So those are the, and I think there may have been negligence claims in Mill Harbour as well, because not everyone was a buyer of the.
I think there was claims. They divided into two. There were contractual claims, I think, under the terms of the lease, and the others were claims for breach of the Defective Premises Act.
Okay. So again, statutory torts, if you like. So then moving on to the John and Rees case, which is my lord Justice Lewison rightly said was a dispute amongst the Pembrokeshire Divisional Labour Party over its assets and control of the party, having expelled the local MP and split into two factions. And I won't go into the facts, but if we could go to the judgment in the bundle numbering at page 126, Mr. Justice McGarry, after a long hearing, gave this detailed judgment. And just above the letter H on page 369 in the report, he says the classic statement is that of Lord Macnaghten. He set that out. And then after setting that out, on the next page, he says, this seems to me to make it plain that the rule is to be treated as being not a rigid matter of principle, but a flexible tool of convenience in the administration of justice. And he then referred to a number of other points. And he says at H, at the bottom of the page, I would therefore be slow to apply the rule in any strict or rigorous sense. And I think that's probably all I need to take you to for the present time. Then Prudential, which is, so there were two judgments by Mr. Justice Finemont in Prudential. First of all, at beginning of tab 6, Prudential Assurance and Newman number 1, where he had, there was some initial debate about whether representative proceedings were appropriate or not. And one goes in the first report in our bundle numbering at page 181, which is page 245 in the report. In fact, it starts a little bit on it starts on the previous page, page 180 in the bundle numbering, where he set out the rule. He referred to the Duke of Bedford case, and at E on page 181, he said consideration of the history of the rule thus militates any narrow construction of it, it led Lord Lindley to say, and that's what we've just looked at, what Lord Lindley said in the Taff Vale case, and referred to some other cases, and then having considered that and considered the initial the submissions in that case, he held that he would allow it, although there were certain restrictions. And if you look at the bottom of page 187, he said these cases, in my judgment, established two propositions. And turn over the page. He, having set out the two propositions he said were established, he says that in the fifth line, he says these two cases do not, in my judgment, establish the wider proposition for which Mr. Scott contends, namely that the court has no jurisdiction in any circumstances to entertain an action by a plaintiff claiming to represent a class in cases where the cause of action of the plaintiff and each member of the class is or is alleged to be a separate cause of action founded in tort. This was the preliminary ruling on this, so he then summarised the position on page 190 between G on page 190 in the bundle, which is page 254 in the report, to page 255 in the report. I won't dwell on that now. So he then had the trial of the case, following on, I think, almost immediately, well, I think directly after that ruling.
This is the trial of a representative action.
Yes. And then at that, so he obviously had the point taken as a preliminary point at the trial by Mr. Scott that there was no jurisdiction to proceed in that way. He dismissed that. And then if we go to the numbering in the report continues on, and it's all the same report. So if we go to page 303 in the report, 303, that's page 240 in the bundle numbering. He held the claim in conspiracy. 240 in the bundle number.
240, 240.
240, yep.
Thank you very much. Yep.
Just below the level C. So having held that the claims in conspiracy succeeded, the Prudential had put in evidence of loss. And you can see he says, but the evidence adduced by Prudential, the representative claimant, is in my judgment sufficient to show that it and other shareholders have suffered some damage in consequence of the conspiracy. And that is sufficient to complete their cause of action, the amount of the damage being, if necessary, referred to an inquiry. And so there would have to be an inquiry as to what loss had been suffered by each of the represented parties, but nevertheless, it was a tort case, damage had to be proved, and he said that it had been proved sufficiently for it to then go on and for there to be an inquiry. Then if we go to the first of the British phonographic industry cases, EMI and Riley, that's in tab 8 of the bundle. So if we look in the head note, the representative claimant, this is page 303 in the bundle numbering. Look in the head note. This was obviously a claim brought by EMI, the Railway and Record Company. And if you look about 7 lines down in the head note, it says their claim made on behalf of themselves and on behalf of all BPI members was for an injunction to prevent further infringements of their copyright and an inquiry as to damages. And Sir Justice Dillon dealt with the matter. And if you look on page 305 in the bundle numbering, page 925 in the report, and the second full paragraph on that page says paragraph 7 of the statement of claim asserts that the members of the class have consented to all pecuniary remedies granted in respect of actions for inter alia infringement of copyright in sound recordings and selling counterfeit records, and all sums paid in settlement of such actions, being actions conducted by the solicitors to the BPI, being paid to the BPI in order to defray the expenses of detecting and suppressing the pirate and counterfeit record, and like trades, and it asserts further that the action is being conducted by the solicitors to the BPI. So although EMI was the representative claimant, that was the position. And we say functionally, that is very similar to our position, where we have a committee who has authority on behalf of all of the claimants to, as I shall be showing you in due course, to deal with the damages or any other remedy and take decisions on their behalf.
But doesn't this, at least in part, turn on the function of the BPI? As Mr. Justice Dillon says at 926, he says the fundamental factor is the special position in this particular trade of the BPI. This is not a case of a small number of manufacturers getting together, etc., etc. And yes. He set out what the BPI is, and that the class are members of the BPI.
Yes. Yes.
That seems to be the key point for him. And yes. Of course, one knows that the collection societies, PPL and so on, have copyrights assigned to them by the copyright holders, precisely for the purpose of centralising the policing of copyright infringement or claiming license and so forth.
But the point was that the damages, I mean, if you go to on that same page, if you look at the top of the page, page 306, he says the minutes of order then ask for an inquiry as to what damages the members of the class have sustained by reason of the defendant's infringement of copyright and conversion of infringing copies, the cost of the inquiry to be reserved, and the plaintiffs to recover judgment for such sums as are found due, together with interest thereon, without prejudice to the allegations. So, yes, they had agreed inter se as to how the damages would be used, which we say is the equivalent of what has been done in our case. But so far as the defendant was concerned, they still had to prove, and there had to be an inquiry as to what damages had been suffered for each breach of copyright. And at the bottom of the page, he says he thinks it's appropriate in the circumstances that EMI should recover the damages in the representative capacity, and he therefore held, right at the bottom of the page, it's appropriate that the inquiry as to damages should be in the form set out in the draft minutes of order. But it must be clear there's to be no duplication of damage.
So it comes back to your basic point. The type is breach of copyright. The loss is differentiated.
Yes. Each copyright had been breached. It was a different copyright and was being breached differently, and there had to be an inquiry as to what that loss was. Once the damages had been then assessed, it was agreed that they would all be paid to the British phonographic industry, the unincorporated, or the association. But that didn't alter the fact that as between the claimant, EMI, the representative claimant, and the defendants, the individual position of each breach of copyright had to be considered. That's my point.
There's no real analysis of what's meant by same interest, but I mean, as my lord says, when one used to turn up in the motions court, as it then was, almost every day there was a claim by a copyright society for collective action for a breach of copyright, and the courts just granted them. But your point is simply the type is breach of copyright. That always justified a representative action, even though the loss was differentiated.
Yes, and each tort, each separate tort has a separate loss of the same type, and they've agreed how it will be. They've agreed inter se as to how it will be handled, and that is part of the reason why it's a relief which is beneficial to all, because that's how they've decided they will deal with it. We come in on and we see the Vice-Chancellor in the next one, he says it's of no concern to the defendants how they've decided to deal with it, inter se. So that's EMI and Riley.
I think that's right, isn't it? I mean, that's a basic rule of damages. You get the cost of repair, but you're not required to do the repair. That's not a matter for the defendants. It's up to the claimant.
Yeah.
It's nothing to do with representative actions. That's just basic common law.
Yes, I think that's right. Yeah, I think that's right. So if we go to tab 12. I am passed a note, by the way, that the transcribers would like a short break.
No, I've said no.
You've said no. I didn't know that, my lord. No. Okay. Now, tab 12 is the Independiente case. So this was a decision of Vice Chancellor. And in this particular case, it was Independiente, that's the right way to say their name, who were suing as the representatives. If you look at paragraph 3, you see that on the 23rd of August 2002, the claim form in these proceedings was issued by the claimants seeking an injunction, damages, or an account of profits and delivery up of infringing copies. And the claim form states the claimants are suing on behalf of themselves and for and as representing all other members of the British Phonographic Industry Limited and Phonographic Performance Limited. So they were suing on behalf of everybody in that who were members of that, just like the other case. And if you go to paragraph 10, I won't take too long on the facts, but the mechanism for how it was going to be dealt with inter se is referred to in paragraph 10 there. And you see, go over the page to 395, he sets out part of it, what the rights that the members granted to the association. And then if we go over to page 398, he talks about having the same interest test, which is paragraph 21. He refers to the Duke of Bedford case, the passage we've looked at. He also refers in paragraph 23 to the John and Rees case. And then in the third line, he says the provisions of the civil procedural rules, particularly CPR Rule 1.2, emphasize the need to interpret the phrase the same interest and to apply the provisions of CPR 19.6 both flexibly and in conformity with the overriding directive. There are 3 questions. To the individual claimants, on the one hand, the relevant members as defined, on the other, have a common interest, 2, a common grievance, and 3, the relief sought by the claimants in its nature beneficial to the relevant members. And he then answers those questions, talks about the common interest, and then the common, the second question. And then at 26, he says, with regard to the benefits, he referred to the argument, and he says that he didn't accept those submissions. The common interest arises from the fact the claim as pleaded is in respect of the UK copyright in a sound recording to which any relevant member is entitled as owner of exclusive licensee. So, translating into our case, for example, the class we are saying here is any of the persons who had the land affected by the Bonga oil spill. There it was all the copyright holders as set out there. And then at 28 he says the relevant relief is either injunctive or pecuniary. As far as pecuniary relief is concerned, it is in its nature equally beneficial to relevant members as to the individual claimants. What they do with any money recovered in the action is a matter for them, not the defendants. think that's the relevant part, but it does continue in the next. My bundle is split at that point. It continues in the second bundle.
The focus here is on the nature of the relief being equally beneficial, as opposed to precise quantum.
Yes, because again, obviously, there would have to be an investigation as to what the position was with regard to each breach of copyright. Moving on as quickly as I can, Emerald Supplies, which you've looked at, was a particularly unusual case, but this is in tab 14, with a claimant who imported flowers into the UK using the British Airways air freight services. And it said there'd been price fixing agreements with other air freight providers, and the claim was brought on behalf of all direct or indirect purchasers of air freight services affected by the alleged price fixing. And BP applied to have that struck out, and that was upheld in Court of Appeal as it had been struck out at first instance. Now,
Sir Andrew Morrich has struck it out.
indeed. Now, we obviously don't. It's such a different case because it was really concerned with the certainty of the class rather than with the point that we are concerned with. But there are nevertheless some important points just to quickly highlight. So in paragraph 3, he cites a passage from Zuckerman, which you may find useful. And it's interesting, if you look at the third line of page 425, it does say one is the true collective interest, where all those concerned share a single common interest, e.g. pollution. So that's what, I mean, obviously that wasn't written in contemplation of our case, but it was what Professor Zuckerman thought when he wrote his book. Now, then, Lord Justice Mummery says in paragraph 4, no group litigation order was sought in this case, which relates to the jurisdictional and discretionary aspects of an order for representative parties. And he then goes on, he says, as Professor Zuckerman explains, the key factor in representative proceedings is identity of interest in the relevant group. That identity of interest is determined with a view to promoting the litigation objectives of justice, economy, efficiency, and expedition. Although the modern trend is to give the rule an increasingly liberal interpretation so that the court can deal with as many claims as possible within one set of proceedings, Professor Zuckerman comments, it's not surprising that the use of this procedure has so far been confined to situations where the interests of the representatives and represented were virtually the same. That approach, and this is what's really important, that approach is conditioned by two principal considerations. First, the binding effect of the proceedings on the representative persons, who have not given their leave to litigate on their behalf, and do not collectively or actually actively participate in the proceedings. And secondly, the limited powers of the court to ensure that the proceedings are conducted in the interests of all the represented persons. The potential presence of separate defences also militates against representative proceedings by claimants. Now, there are 3 points there that are worth picking out and just considering whether they apply in the present case. One is that the possibility that persons may be bound without having given their consent to the proceedings. Well, that factor is entirely absent in the present case, for the reasons I'll explain when we come to the facts. The second is the potential for there to be conflicts, which was actually a real problem in this particular case, because he went on to hold that there could be conflicts of interest between members of the class, because the direct and the indirect purchasers of air freight services could well have a conflict of interest between them, and that was one of his key pieces of his reasoning. And the third point is that the potential presence of separate defences, which he said militates against representative proceedings by the claimants. A defendant should not be prevented from raising a defence that he may have against only some of the persons represented. And Mr. Justice Aikenhead also dealt with that. You'll see that he says that that's not a bar to there being representative proceedings. We can be sufficiently flexible to cater for that.
By having a date.
I'm sorry, Madam.
By having a date.
By having a date for limitation and for other ways for
Mr. Justice Aikenhead in Millharp,
yep.
He dealt with that by having a date.
But in terms of
having a bit of difficulty teasing out the jurisdictional point that you make and the discretionary point. So if something militates against, but is not a bar,
yes,
that sounds as though it's a discretionary point, and likewise with the date cut-off, which you answered, my Lord Justice Coulson, would also seem to be a discretionary point,
yes,
rather than a scope of the rule point. So my question therefore is, are you quite right in saying that you have raised a purely legal construction point on the rule, and that if you succeed in showing that your action is capable of being within the rule,
yeah,
that's the end of it, and neither the judge nor we should go on to consider whether, assuming that you are potentially within the rule, you ought to be allowed to pursue a representative action?
Well, I see that point, and the reason why I have, let's just take the limitation point. The reason why I have said there is another way of dealing with it is because the learned judge held that the possibility of separate defences militated against there being the same, or was a factor as to why there wasn't the same interest. Now we say that's he's got it the wrong way. I mean, I was going to deal with this when I come to the judgment, but we say he's got it the wrong way round, because the claimants have to prove that their property has been damaged, and they will also have to prove, in terms of the limitation period, they'll have to prove when it was damaged. So those are things that the claimant has to prove. They're not really. There may be defences that arise out of those, but those defences are simply the opposite side of the coin of what the claimant has to prove. Namely, that the property has been damaged and when it was damaged in time.
Those are the sorts of factual disputes which will naturally occur in a representative action.
Yes.
I think your analysis, it doesn't.
Yeah.
One doesn't preclude the other.
Well, as soon as soon as damage has to be proved as part of the cause of action, that will inevitably happen. So unless the court is going to say, and reverse some of these cases, which says that representative actions can be brought for tort claims where damage has to be proved as an element of the cause of action, if this court's going to say that's wrong, we say it's right, and the copyright cases make sense, provided there is a common interest in the relief. And that element is covered where it's all the same type of damage, and the claimants have agreed inter se as to how the damages should be allocated. And they've got a committee who's in charge of deciding what should be done on their behalf. Just as it so happened that all the copyright holders in the, at least the Independiente case, had all decided, all assigned their rights to the damages to which they were entitled to the British Phonographic Industry Limited. Now, and then it became of no concern how much individual persons got, whether they got the same amount or different amounts. That was something. Obviously, there had to be an inquiry as to what those amounts were, but what they then did with the money, as between themselves, was irrelevant.
But is that, I'm just trying to get clear in my own mind what kind of a decision that is. Is that, as it were, an evaluative, multifactorial judgment, as we now like to call it, or is it discretion? What is it?
Well,
I mean, of course, I can well see that the rule applies to tort. So, I mean, if a cricket club wants to sue for trespass to its cricket pitch, then the committee members or it's an unincorporated association, and obviously be a representative action.
yes,
Because the unincorporated association is not a legal person.
yes.
So, I mean, I don't have a difficulty with saying it applies to tort.
But the cricket club might be different because if let's say the pavilion was damaged or the pitch was damaged, it's one item of property effectively. But the independent case and the EMI case are not about one item of property. They're about hundreds or maybe thousands of breaches of copyright, of different copyrights. So if you like, it's like equivalent of hundreds or thousands of different cricket pitches being damaged. And nevertheless, provided they've agreed to deal with it in the way that they have, then there's a common interest. And
so when you say that the claimant has to prove damage and has to prove when, in this case, that's the 28,000.
Yes, it has to be proved when the property in which they claim an interest was that it was harmed and when.
Yeah.
Yeah. But we come back to the point that that's not a function of the representative action. It would be the same if it was all owned by one person.
Yes.
Because we're not
Neither
relying
is
on
it
the
a
individual
function.
characteristics of the owners.
No,
Yeah.
it's to do with what needs to be shown, but
Yes.
therefore there's no difference in that with having the 28,000 as claimant. So we go back to the point that it was started as a representative action, and that's what you now need to demonstrate to save the limitation position.
Yeah.
And it's nothing to do with case management, flexible tools, or anything else.
But if I could, I'll just finish with this case then, and before I come to we've got a couple more before I come to the facts. So where, after discussing the case, where the paragraphs where Lord Justice Mummery expressed his conclusions are paragraphs 62, 63, 64, and 65, and you'll see that the critical features in that case are identified and discussed there, and in particular the lack of identity of the class, potential for conflicts between them, and the fact that persons who may not have given their authority might be bound by the outcome. All of those features, which are not present in our case. I then go to the Mill Harbour case, which is tab 15. This is the case of the block of flats involving 350 flats, and my Lord Justice Coulson is entirely right about the two categories. If you go to paragraph 15 on page 443 in the report, you'll see there were some earlier attempts, but the final version of the proceedings is set out in paragraph 15, and there were two categories. A, as suing as a representative on behalf of all private leaseholders of the flats, not being currently claimants who entered into a contract of purchase, and then B, behalf of all private leaseholders not currently claimants who did not enter into a contract with the defendant. So you're exactly right about that. And their claims were made under the Defective Premises Act 1972. Now, it was alleged that there was a whole variety of defects. I can see that in paragraph 10, for example, in the judgment. I don't think we need to go through that now. But then if we go on to paragraph 19, the judge there examined the history of the representative action and referred to an article.
Sorry, just before we go, who's the defendant? They're the builders, are they?
Yes.
The developers?
Just
Sold, all of the flats are sold to a housing association, remainder sold to individuals. Mill Harbour is the management company.
they were the developers, my lord. The defendants.
Developers, right.
Yeah.
Thank you.
I had assumed developers because I had assumed that they developed it and then
Sold it.
but on the leasehold basis, because that's why the Jan Hills was a representative on behalf of all private leaseholders. I assume
Who had a contract.
who had a contract with the developer.
Yeah, and then some didn't because they had bought from other
the housing
persons who had.
association,
Yeah. So paragraph 19, he examines the long history of the representative proceedings and refers again to the Duke of Bedford's case. And then in paragraph 20, on page 445, he says, as the law and practice has developed, it has been held that a claimant is entitled to sue in a representative capacity for others and seek damages. The representative claim is not limited to declaratory relief, and he refers to EMI, and he refers to Emerald. That must have been the first instance decision in Emerald, because he refers to Sir Andrew Morritt there. Then he also, who had then, so then there's a quotation from his judgment, and including where over the page he refers to Prudential Assurance and Newman. And having looked at all of the background, you see reference to the Irish shipping case and the National Bank of Greece case and also Independiente. At paragraph 22 on page 449, Justice Aikenhead set out his very useful summary of the general principles. And I won't read all of that. But at point 4, for example, he says, as in the Duke of Bedford case, it will be inappropriate before the final judgment of the issues resolved in relation to the represented parties for the court to decide the issues, or indeed to indicate in some obiter way what the answer may well be. That is simply because the court will not have heard full argument, will only have unchallenged written evidence before it at that stage. At 6, he says the overriding objective must always play an important part in the exercise of the discretion, picking up my Lord Justice Lewison's point, and then limitation defences could be a factor to be taken into account. He says, in general, however, it will be open to a defendant to run a limitation defence in relation to represented parties who are not actual parties in litigation, if such defence was established against certain persons, be wholly exceptional. And then he comes back to dealing with limitation. If we go over to page 452, he talks about the exercise of discretion, and actually I might just indicate what he says between C and D. It would be extraordinarily cumbersome and costly procedure for hundreds of claimants to be parties to the proceedings, although historically this has happened. It becomes further complicated because inevitably leasehold owners move on or sadly sometimes die during such litigation. So the amendments to the parties' names have to be made. Initial costs of securing instructions from each leaseholder would cumulatively add up to a substantial amount, although the existence of an additional 180 claimants and proceedings would likely add little or nothing to the merit or demerit of the claims and defences.
But in this case, all the leaseholders, as I understand it, were required to pay a service charge. That service charge would include the remedial works which they said needed to be done.
Right, yeah.
And the extent of the representation was limited, see paragraph 15, to the cost of works to be charged to the leaseholders through the service charge. They all had this liability under the service charge, and the representative quality of the action was limited to what might be recovered from them through the service charge.
I think that's probably right, my lord. I'll check if come back if that's wrong. And then he dealt specifically. Just the final point I want to draw attention to is with limitation in paragraphs 34 and 35, and I've summarised that already this morning. So that's that case. We said that was a pragmatic handling of the matter. Then there's the Lloyd and Google case. As your lordships have read that case, I won't take too long with that. What is important, however, with the Lloyd and Google case is to have in mind what Mr. Justice Warby had held, and we've dealt with that extensively in our skeleton argument. So I won't. But that is important context, because Mr. Justice Warby was critical of what he called was a sort of tactical device. And the Court of Appeal said, no, you're entitled to frame the case the way that you choose to frame the case. There's nothing improper about that.
But they just said it was acting on a concession, in effect.
Yes.
The concession was made, they were entitled to do so.
I would be happy to accept, for example, in our case, that it's a tactical move, but it's nothing pejorative about being tactical. One's entitled, in every case, to frame one's case in a way that takes the best advantage of whatever relief and remedies the court's rules allow you to. So, although it might be tactical or even strategic, there's nothing pejorative about that. There's nothing contrary to public policy in framing your case in a way that takes advantage of procedural rules. And that's really what the Google Court of Appeal decision held, that it was there's nothing wrong with that, and Mr. Justice Warby was wrong to criticise them for that. And there is a trace of this in our case, because the judge below described it as an expedient, and it sounds sort of pejorative. I mean, it may be that he didn't attach much weight to that point, but if he did, if the court thinks he did, we say that is wrong. One's entitled to frame one's case in such a way as to take advantage of whatever procedural rules allow you to do. There's nothing wrong, improper about that. So that's one of the key points there. The other key point about Google is that although Mr. Lloyd had given away the individual position of the claimants, the one thing he couldn't give away, if you like, or he had to maintain, is that each of the claimants, represented claimants, had to have not consented to the extraction of his data. So in whatever way it was going to be established or proved, nevertheless still had to be established that there had been an extraction without consent of the data of all of the members of the represented class. He really, Geoffrey Voss, Master of the Rolls, really dealt with the common interest point starting at paragraph 73, because of course there was a lot of debate about the nature of the damage, and indeed the cause of action. And at paragraph 73, page 638 in the report, he starts to talk about the same interest. He said he didn't find the cases of such use in paragraph 73, although funnily enough, when we come to paragraph 75, he does then circle back to the Duke of Bedford case. He said at paragraph 74, the fact that, as Mr. Justice McGarry said, and John and Rees the rule is to be treated not as being a rigid matter of principle, but a flexible tool of convenience in the administration of justice, cannot mean that the same interest test can be abrogated. In my judgment, however, the judge applied too stringent a test of same interest, partly, I think, because of his determination as to the meaning of damage. Once it's understood that the claimants that Mr. Lloyd seeks to represent will all have had their BGI, something of value, taken by Google without their consent in the same circumstances during the same period, and are not seeking to rely on any personal circumstances affecting any individual claimant, whether distress or volume of data abstracted, the matter looks more straightforward. The represented class are all victims of the same alleged wrong and have all sustained the same loss. Now, just pausing there, he obviously doesn't mean quite what he appears to say, because he must mean loss of the same type. He doesn't
Is
mean,
that right?
well, he can't mean...
He says the loss is loss of control over their BGI.
Yes.
That's the same for all of them. That's not type of loss, that's actual loss. They've all suffered a loss of control over their BGI. So
well,
I don't think I think that the Master of Rolls is saying exactly what he means, isn't he?
Well, yes, he is, but when he says, namely, their loss of control over their BGI, he's saying they've all suffered that type of loss. He's not saying that it hurt them in exactly the same way, because some of them may have been big data users and had a lot of sensitive information. Some have had no sensitive information taken.
That's where the concession comes in, by homogenising it.
Yeah.
In a sense, they stripped out of the analysis factors which might otherwise have been differentiated. It's not necessarily indicative either way, but it enabled the court to say, actually, on the facts of this case, there's a great deal of commonality.
Yes. And then he goes on, he says, Mr. Tomlinson disavowed, as I've said, reliance on any facts affecting an individual represented claimant. And we say we're in exactly the same position as that.
I don't understand that.
Well,
I don't understand that at all. I mean, if I have land in, I'm sorry to use Belgian examples, but
yeah.
I'm a bit more familiar with Belgian geography than Nigerian. If I have land in Ypres, which has been heavily polluted by
Yeah.
oil, and it needs a massive clean-up, and somebody else has land in Antwerp, which has been lightly spattered,
right, yes.
surely the court will have to take into account the facts affecting any individual represented claimant, because the court will have surely to inquire what needs to be done on this parcel of land, what needs to be done on that parcel of land, how is this scheme going to work?
Yeah, no, I see that, but and my answer to that is one I've already given, which is that it would be the same if the same person owned all of them. It's not attributable to the individual characteristics of the owner. It's just a function of geography.
Well, I follow that, but that's because the tort, the main tort, is a tort which is itself a function of geography, not the individual owner, because it's an interference with a property right,
Yes.
not a personal right.
Yeah, no, I see that. But that's the point. And taking that in the round, where they're all claiming the same relief, they have the management committee, steering committee behind them, and one starts with, in effect, a single incident causing this pollution, albeit that then the pollution arrives in different places at different times. So I'm just reading on. He says that concession has the effect, of course, of reducing the damages that can be claimed as to what might be described as the lowest common denominator. Does not, I think, as the judge held, mean that the represented claimants do not have the same interest in the claim. Finally, in this connection, once the claim is understood in the way I described, it's impossible to imagine that Google could raise any defence to the one the represented claimant did not apply to the others. The wrong is the same and the loss claimed is the same. The representative parties do, therefore, in the relevant sense, have the same interest. Put in the more old-fashioned language of Lord McNaughton, representative claimants have a common interest and a common grievance, and the relief sought is in its nature beneficial to all. And of course, we don't say our case is exactly the same on the facts, but we do rely on the reasoning by analogy. Now, what I'd like to do now is just briefly summarize the relevant facts and just draw your attention to one or two pieces of the evidence which are not fully reflected or reflected in the judgment, but which were argued below. Again, it's a series of points, but they shouldn't come as a surprise, or most of them shouldn't come as a surprise. Firstly, is that the claimants, all the parties and all the represented persons, all say they are victims of one and the same incident, namely the Bonga spill in December 2011, which on their case has negatively impacted all of their environments. Everything arises out of what happened at the single berth mooring in the Bonga oil field, and how the defendants and those for whom they are vicariously responsible responded to the spillage and failed to stop or contain it. And there will be a very substantial factual inquiry and legal debate, which is common to the claims of the entire class. And it's actually an interesting point that we haven't found, in all the cases that we've looked at, any cases which, or any cases of note anyway, where there are representative proceedings arising out of a single incident. Nearly all of the cases, as we've seen, are what you might call course of conduct cases, where British Airways have done this over a period of time, or the breaches of copyright have occurred over a period of time. The closest single event case might be the Prudential and Newman case with the conspiracy which causes loss to the shareholders. But there doesn't...
Given the number of days that case took, both at first instance and I think in the Court of Appeal, I would be surprised if that wasn't a course of conduct case as well.
It became one.
I was going to say, I think if that was a one-off incident, then somebody might accuse the judges of rather poor case management.
Yeah, no, I mean, I'm not even sure that is. But, so it is an interesting point, because Professor Zuckerman has flagged up that in the passage we saw that the representative actions may well be suitable for environmental harm, but there doesn't seem to be a case of this type, or even of the single incident type, that we can easily go to. So what Lord Lindley said is still apt, namely that one doesn't have to find a precise precedent. One is trying to go from first principles here. Those first principles being largely derived still from what Lord Macnaghten said in the Duke of Bedford's case. So the position is that factually, every single claimant and all the representative parties are advancing exactly the same factual allegations of wrongdoing and wrongful escape of oil up to the time when the oil reaches the Atlantic shore. And that is a very different starting point from many of the cases. For example, the breach of copyright cases are concerned with hundreds, if you like, of separate infringements of copyright in a course of conduct. Following on from that, and in some ways it's the same point, but it's a consequence of that, there is nothing to differentiate the claimants and the represented persons in terms of what they wish to say in relation to duty of care, breach of duty, and causation of the initial release and the failure to contain and failure to treat the oil. They have entirely common cause in relation to all of that. And as a consequence of the first 2 points, thirdly, they are all relying on the same legal case or case theory, the same 3 common law causes of action of negligence, nuisance, and Rylands and Fletcher. And there's, again, no difference at all between their legal legal case theories or claims, causes of action. The claims are, of course, all brought against the same two defendants. Now, the next point is that the great majority of the affected land is held on a community basis. And Mr. Jalla had given evidence about this in his sixth witness statement, which we can find in the supplemental bundle in tab 18. Supplemental bundle, page 157. This paragraph 25, page 157, starts by discussing another point, which I'll come back to, but I will read the whole paragraph now. He says, in my first witness statement, I've explained at length the way in which the steering committee and the communities and individuals were set up to manage this claim, and I refer the court to this. As I previously stated, the power to bring this claim and organise the management of this claim is invested in the steering committee. Power is invested in the steering committee both by the heads of the affected communities and also by the individual claimants alike. I became a lead claimant because the steering committee nominated me as such. The steering committee has the power to revoke my lead claimant status and replace me with whoever they see fit at any given time. This arrangement is perfectly legal under the law of Nigeria, and it's the most efficient way to manage a claim of this magnitude. And he exhibits a deed of instruction. And then he says the context is also that of the affected areas, the great majority of the land is owned by communities and not by individuals. And this was a point that was which was discussed at the hearing, because there was a point that arose a few times between myself and Lord Goldsmith as to when the communities claiming, the communities that are listed in Schedule 2 to the particulars of claim, are they claiming as communities, or are they claiming on behalf of all the individuals in their communities? So Lord Goldsmith would say, well, if it's on behalf of all the individuals in those communities, that's 300,000 individuals. And we made it very clear that the communities were claiming in respect of community rights. So Mr. Jalla is saying the majority of the affected land is owned by communities, not by individuals. And when we discussed this at the hearing, and if you could then go please to tab 22, in Core Bundle 4, this is Core Bundle 4, tab 22, one has here the transcript of the hearing before Justice Stuart-Smith. And at page CB 1085, on page 96 of the transcript, I said, what I want to make clear is that insofar as the community has claims, or has claims brought on their behalf by Mr. Jalla and Mr. Chuja, I made the same mistake myself, our understanding is that that commonly happens in Nigeria, but obviously we'll have to have evidence about that. But I want to make it absolutely clear, this is not intended to be a claim by the individual inhabitants of the 457 villages and communities. It's a claim brought by Mr. Jalla and Mr. Chuja in respect of the community rights in those communities or villages. That is to say, communal land, communal wells, those sort of things. There's no intention there to bring in a whole cohort of individuals with any sort of loss attributable
to their own possession or ownership of property. I hope that's clear. And
So if there is an individual who owns property within a community, there might be overlapping claims, one by the community for communal rights and the other by the individual for damage to his own land.
Yes, and there are of course, in Schedule 1, claims by individuals for their own property. Yeah. But this, I'm talking
And are
just...
some of those in the 457 communities.
Yes, the majority of them are. There are
Is there
few that aren't. There were relatively few anyway.
Is there a map anywhere? I mean, there's some very poor maps in the supplemental bundle, and I'm afraid I couldn't even work out for those, as it were, where the Bonga community was. And rather like my lord, being more familiar with the geography of Belgium rather than this part of West Africa, I was thinking it in those terms. If there is a map,
yes,
and certainly if there is a map that shows the 457 communities, again, speaking for myself, I'd be hugely assisted by that.
I've just taken instructions. I mean, there's certainly there is a long story about maps, but I'm not the person at the moment to tell you where we've currently got.
I'm maybe less interested in the story and more interested in the map.
I'm just trying to find out whether a map was served in the package on Friday, and I'm not familiar with that, I'm afraid.
Well, don't wait now. But
so that is what was said about that aspect. The next point I wanted to make clear is that obviously by the time of the hearing before the learned judge, we had made clear that the relief in paragraph 1 of the prayer was not being pursued, and it was paragraphs 2, 3 and 4, namely the relief for the same type of environmental damage suffered to the land and property caused by the escaped oil. And I made the point to the learned judge that from that point of view, it made no difference who owned that land or property, although the majority of it was owned by communities, because it was the direct damage to the land and property and the need to clear it up. Nothing which was, as it were, nothing was relied upon which was a function of the individual characteristics of a claimant.
just for my note, that the point about paragraph 1 no longer being pursued, there's not an amended pleading that shows that.
No, but it was very clearly set out in writing in our skeleton.
Can we just have the note of that?
Yes, well, I think that was the next. The next point I was coming to was to say that there was nothing new about this. It was always there, and we gave in our skeleton argument. We've given you the references to that. That's paragraph 39 in our skeleton argument for this appeal, and maybe I can be told where it was made clear in the skeleton below. So we narrowed and focused.
So 39 of your skeleton for this appeal.
Yes, deals with the history of the pleading.
Yeah, no, that's fine. I don't need to look. I just need the.
But I don't think that actually answers your question, which is when did we make it clear? Certainly, it was made clear in the skeleton argument for the hearing, for the learned judge. Yes, the paragraph 39 deals with the fact it was always there. Yes,
41 of your skeleton, is it?
Now, the next point is that it was always the intention, so far as damages were concerned, for the money to be paid into a common fund. And this is the point about there being a committee, which in the passage I read you from Mr. Jalla's 6th witness statement, paragraph 25, he refers to as a steering committee. I'm instructed that's the same as what is referred to elsewhere as the management committee. So if we could go back, please, to the supplemental bundle at tab 2. In an earlier statement, his 4th witness statement, which starts at SB 58. And in paragraph 10, Mr. Jalla talked about the formation of a charity called the Oil Spill Victims Initiative, and had a constitution, and he attaches a copy of the constitution, and he says, if you look at paragraph 14 over the page, as the charity prepared for group litigation in early 2017, the individuals involved recognises that we are required to formalise its administration and governance, drafted a constitution and applied to the charities body, equivalent of our charity commission, I think, in the middle of 2017 for formal registration. Formal registration was refused under the original name, and so they changed the name slightly. And that's more detail than we need. If we then go to the next tab, you'll see the Constitution. This is starting on page SB 70. At page SB 71, it has the Article 4, the aims and objectives, and those include, at subparagraphs 5, participation in all negotiations, preparation of all texts, acts, guidelines and regulations, as well as distribution of allocation of funds that are the direct or indirect result of compensation to victims and communities of oil spill and hazards of gas flaring. And 7, to administer a general benevolent fund for the victims and communities of oil spill and hazards of gas flaring. And we drew those passages to the learned judge's attention in this context on in the question of the relief beneficial to all, and that was I don't think I need to take you to it, but it was in our skeleton argument below, which is in the supplemental bundle at tab 19, page 200, paragraph 272 through to paragraph 274, exactly the passage I've just taken you to. And then I mentioned that at the hearing before the learned judge. And I'll show you, if I may, the transcript. And this is back in core bundle 4.
So, just assuming a monetary award is made,
yes, they've agreed inter se that
it's
it will
not going to be paid to Mr. Jalla. It's going to be paid to the charity. Is that?
Yes, which he's one of the moving persons behind it. And then we discussed this during the course of the hearing at tab 22 in the
Core bundle 4.
core bundle 4 at page 1084. And picking it up on the transcript, I think on page 91, which is the page in the top right on page 1084, I pointed out to the judge that when you wrote your judgment, that was his original judgment, you said what you did in paragraph 1, and then I said that's how the proceedings have been brought by the first and second defendants on their own behalf, on behalf of the listed individuals in Schedule 1, on behalf of the listed villages and communities in Schedule 2. And then going to the next page, 92, as I said earlier, the constitution of the OSP IVV, which was just looked at, reflects that it was the intention to pursue the proceedings and obtain compensation and have them set up a general fund for the victims and the communities. That's in Article 4, which is in the supplemental file. And I said, that's consistent with the way that your lordship read it when you wrote the first judgment. And Mr. Justice Stuart-Smith said, yes.
So that the charity can distribute to people whether or not they are represented in this action.
Yeah, so that all the persons who have represented have given their authority for the money to be handled by the charity.
Yeah.
And that's really why we say our case is getting closer to the British Phonographic Society type of case. the relief will be beneficial to all, even if they don't all prove, because that's what they have decided as their project, if you like, that they wish to do. They wish to pursue this group remediation for the benefit of potentially all of them via the charity.
And that's
So if, let's assume you prove your case, Shell are liable, the court decides, well, we can't make an order requiring Shell to clean up, we'll award money instead. That gets paid to the charity.
Yeah.
Open to the charity to say, well, we're not going to clean up, we're going to distribute to the victims of the oil spill. We don't have to worry about whether they do or don't have a cause of action in nuisance. If somebody has been have had their health affected, whether or not they might have had possession of land, we're going to make them a grant.
Because they've all signed up to that, as I understand it. Rather like the all the members of the British phonographic industry all sign up to say that the fruits of their actions for damages for breach of
It rather shifts the focus away from what you say is the purpose, which is clean-up. If the charity has a pretty much free hand to...
Well, the purpose is clean-up as between the claimants and the defendants. But it comes back to what the Vice-Chancellor said in the Independiente case. It's nothing to do with the defendants, what the claimants then do with the money.
Yeah, I understand that.
I mean, it's obviously it's not exactly the same.
That's post-litigation, if you like.
Pardon?
It's post-litigation.
Yes, and it's an agreement inter se as to how they will handle the proceeds.
And at the time
for the benefit of all.
And at the time of this, both the statement and the constitution that is attached, this related to all payments.
Yes, all payments. And even if it's
therefore, in Jalla 2, all that money as well is going to the charity.
I presume so, yes.
Well, I mean, that must be right,
Yeah.
because Mr. Jalla's witness statement is October 19, so that's before the year before the strikeout and all the rest of it. And if the term is the same, allocation of funds that are direct or indirect result of compensation to victims and communities.
I think that's right. But from my perspective, the important point is, even if it's a patchwork of success, as the judge put it, it doesn't matter because they're all benefiting because of the way that they've chosen to agree matters inter se.
Right, would that be a convenient moment?
Yes, landlord. I've very nearly, just to catch up with where we are, very nearly finished what I wanted to say on the facts. I've shown you
I think we're going to the judge's reasons.
and then we're really on to the judge's reasons.
All right, let's do that. It's 2:05.